Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss whether non-advocates can be permitted to appear before the consumer fora or not. Basically, remember, there is no hard and fast rule that in the consumer courts or consumer fora, the presence of advocate is necessary. But still, when you appoint an advocate, so he cannot divest all his functions to a non-advocate. This is the problem. Justice Sanjeev Narula of Delhi High Court, in the case of Anuj Kumar Chauhan and another versus Lt.Goveenor National Capital Territory Region of Delhi and others. WP Civil 17773 of 2024 held that non-advocates or agents can be permitted to appear, to sign the documents, but not to submit the arguments and prosecute the case. వాళ్ళు అపేర్ అవ్వచ్చు, తప్పే లేదు. డాక్యుమెంట్స్ ఏమైనా కావాలంటే తీసుకొచ్చి ఇవ్వచ్చు, వాళ్ళకి ఏదైనా నోటీసులు వస్తే తీసుకోవచ్చు. కానీ ఆర్గ్యుమెంట్స్ చెప్పటం, కేసెస్ సైట్ చేయటం అంటే అడ్వకేట్ లాగా అన్ని పనులు చేయకూడదు. That is what is stated in the particular case. The practice of permitting non-advocates to appear before the court, of course, in all aspects it can be allowed, but not fully. Right? ఇక్కడ ఎందుకంటే procedure also you have to learn. So there is a procedure, that is rules అంటాం కదా మనం. As per procedure for regulation of allowing appearance of the agents, non-advocates, right, voluntary organizations before the consumer fora. Regulation number 3. These regulations were made in year 2014, out of which regulation number 3 permits parties to be represented by non-advocates also. Right? So representation is different from prosecution, appearance and representation can be there. What is representation? Your Honor, my client is absent, post the case so and so date. Yes, written statement not filed. Yes, I am going to file the written statement on behalf of. So almost GPF holder. అంతేగాని ఆర్గ్యుమెంట్ చెప్పే స్టేజ్కి వెళ్ళకూడదు. రైట్? సో ప్లీజ్ రిమెంబర్, డ్యూ డిలిజెన్స్ ఈజ్ నెసెసరీ and due authority is necessary. Here, if a senior advocate or the advocate who filed wakalat, he wants the case to be pursued by a non-advocate, he has to given him the permission. Yes, you can go and attend, you can argue or you can submit this so and so అని చెప్పి ఇవ్వాలి. ఏమీ లేకుండా వాళ్ళే తమే లాయర్స్ అయినంతగా మాట్లాడితే కుదరదు. ఎందుకని? ఇది మనం గుర్తుపెట్టుకోవాలి. ప్లీజ్ రిమెంబర్, వాట్ డస్ Section 30 of the Advocates Act say? Section 30 of the Advocates Act says that the advocate who is enrolled with the Bar Council of any state, he is only authorized to practice in any court in India, maybe the Supreme Court also. At the same time, please remember, at the same time, he represented by so and so. And please remember, at the same time, they cannot submit the arguments. Since you are not advocate, only advocates are the class of persons according to 29 also. They are the recognized class. According to that, they can appear. No doubt, according to section 32, yes, the court can make anybody to appear before it, but not to prosecute the case. This is very, very important. So regulations regarding this, they are not being strictly adhered to. Right? An advocate here, why this all the problem came is because an advocate effectively delegated all the core professional responsibilities to non-advocate. ఏమేంటవి అన్నీ చేసేయమన్నాడు. సైనింగ్ ద డాక్యుమెంట్స్, రిసీవింగ్ ద కమ్యూనికేషన్ అండ్ ఆర్గ్యూయింగ్ ద కేసెస్. నో, he cannot argue the case. He can sign the document, no problem. So kabatti it is against to Advocates Act 1961. So because suppose if you are advocate, you are guided by or you have to be bound over under the Advocates Act. If he is non-advocate, who can control him? If anything. So Advocates Act is there only to protect the interests of the advocates and at the same time to punish the advocates who err, who commit the so-called, we tell you, professional misconduct. The practice raises serious concern about professional privilege and confidentiality, as non-advocates, they are not bound by the Advocates Act. This is the main problem. So, please remember, the Delhi High Court has correctly pointed out that, no doubt, in the consumer fora, you can delegate your powers to the juniors, to non-advocates also, to some extent only, but not at the full extent. Definitely, it is a boon for the advocates, I am sure. Okay, so with this, I am concluding here. Thank you.